When a prestigious law firm with nearly $750 million in annual revenue allegedly dips into its employees' retirement savings to fund daily operations, it raises a disturbing question. How safe is your nest egg really? A bombshell class action lawsuit has rocked the legal world, targeting Husch Blackwell, a powerhouse BigLaw establishment that generated an impressive $707.8 million in revenue last year and secured the 78th position on the coveted Am Law 100 rankings. But here's where it gets controversial. Despite this massive financial success, the firm stands accused of systematically misappropriating worker retirement contributions in what attorneys describe as a deliberate scheme. The explosive allegations, now unfolding in Missouri's federal courthouse, paint a picture that would make any employee's blood run cold. Court documents reveal that while Husch Blackwell faithfully deducted retirement contributions from employee paychecks, as any responsible employer should, these funds allegedly took an unauthorized detour before reaching their intended destination. Instead of flowing directly into workers' retirement accounts where they belonged, substantial portions of these contributions allegedly found their way into the firm's general operating fund, where they reportedly remained stranded for extended periods, sometimes stretching across multiple months. This practice, if proven true, represents a clear violation of the Employee Retirement Income Security Act, ERISA, the federal law designed to protect workers' retirement security. The Husch Blackwell defendants' breaches of fiduciary duty arise from a deliberate scheme to use their employees' retirement plan contributions for the firm's own benefit. The law, and this is the part most people miss, the human cost behind these corporate maneuvers. The lead plaintiff, Tyler Patekow, isn't just another disgruntled former employee. He's a legal professional who once walked the halls of Husch Blackwell as an attorney before establishing his own practice, the Patekow Law Group. His insider knowledge of the firm's operations potentially adds significant credibility to these serious allegations. The scope of this alleged misconduct is staggering. The proposed class action seeks to represent approximately 400 current and former retirement plan participants whose contributions allegedly weren't transferred within the legally mandated time frame, a pattern of behavior that prosecutors claim extends back to September 16, 2019. Charles Field, the sharp legal mind from Sanford Heisler Sharp McKnight and Fell Law, representing the affected workers, doesn't mince words about the clarity of the law in this situation. His firm has built a reputation for taking on ERISA violations, and Field emphasizes that the regulatory requirements leave no room for interpretation. The law is clear, Field stated emphatically to Law.com. By the 15th day of the following month, those funds need to be in the 401k plan. His methodical approach to investigating potential violations involves rigorous analysis of financial data and fund performance metrics to determine whether legal action is justified. Field's confidence in this particular case is telling. This one was pretty easy to deconstruct. We looked to see if there was something we were missing. We couldn't find anything, exhausted our due diligence, and filed the claim. But here's what makes this case particularly intriguing and potentially controversial. In an era where big law firms are posting record profits and lavishing partners with unprecedented compensation packages, how does a firm with over $700 million in annual revenue justify allegedly borrowing from employee retirement funds for operational expenses? The optics alone raise uncomfortable questions about priorities and corporate responsibility. When law firms preach fiduciary duty to their clients while allegedly violating those same principles with their own employees, it creates a credibility gap that could have far-reaching implications for the legal profession's reputation. Notably, Husch Blackwell has maintained complete silence regarding these serious allegations, declining to provide any public comment or defense of their practices. This strategic silence, while legally prudent, leaves room for speculation about the firm's confidence in their position. The case also highlights a broader issue that many employees never consider: the vulnerability of retirement contributions during the brief window between payroll deduction and actual investment. Most workers assume their money moves seamlessly and immediately into their retirement accounts, but this case suggests that assumption might be dangerously naive. What's your take on this developing story? Should employees have the right to real-time transparency about where their retirement contributions are being held? Is it ever acceptable for employers to use worker retirement funds as a short-term financing source, even if they eventually make good on the transfers? And perhaps most controversially, if a law firm can't be trusted to handle their own employees' money properly, what does that say about their fitness to manage client funds and provide legal guidance on fiduciary matters? This case could set important precedents for how retirement fund timing violations are prosecuted and what remedies are available to affected workers. The outcome may well influence how law firms across the country handle employee retirement contributions going forward. What are your thoughts? Have you ever wondered about the security of your own retirement contributions during that mysterious period between paycheck deduction and account posting? Share your perspective. Do you think this lawsuit represents isolated misconduct or a symptom of broader systemic issues in how law firms manage employee benefits?